We're going to get started in a couple minutes. All right, we're going to go ahead and get started. I'm going to call this work session to order on AO 2021-30, amending Anchorage Title 5, Equal Rights. Let's go ahead and start with the roll call, please.
Ms. Allard? Here. Mr. Peterson?
Present.
Ms. LaFrance? Mr. Dunbar?
Mr. Dunbar is excused.
Mr. Rivera?
Present.
Mr. Weddleton?
Here.
Mr. Constant?
Mr. Constant will be a little late.
Ms. Kennedy? Here. Mr. Perez-Verdia? And Ms. Zalatel? Here.
Thank you. Members in person, you can get in the queue just like any normal meeting, and then for anyone who's on the phone, please text me if you want to get in the queue. All right, so today we have an hour to discuss or begin discussing the Title V ordinance that's going to be before us on the May 25th meeting. We do have the possibility of scheduling a possible second work session. 2 seconds. So there is a possibility to have a second work session on May 21st, I believe is the date. And I will gauge that just based on how far we get today. Before we get started, Mr. Gates?
No, Mr. Chair, that's an erroneous click, I think. Sorry.
Okay, thank you. All right, so we'll go ahead and turn it over to the administration for the presentation.
Thank you, Mr. Chair. Good afternoon. Good afternoon, Assembly members. Thanks for being here on this Friday afternoon to discuss our Title V ordinance. I didn't prepare a formal presentation. This is a long ordinance, and I wanted to be as efficient with your time as possible. I didn't want to get bogged down in slides. So my plan is to just go over the ordinance, just in order. A couple overarching themes that we'll see. So a lot of this is procedural in nature, is cleanup. But some of the overarching substantive themes that we'll see are just updating and modernizing definitions, and then also creating a system of checks and balances on the powers of the executive director, or the powers delegated to the executive director by the commission. I guess I should have introduced myself first. I know most of you. My name is Mitzi Bolaños Anderson. I'm the director of the Equal Rights Commission, and I have Megan Carmichael here with me from the Municipal Attorney's Office. We worked very closely on this. Megan and her team were invaluable in helping us work through this with our commissioners. So again, there's a lot to go through, and I'd like to just jump right in, if that's okay. All right, so our first edit, Title V shall be liberally construed to effectuate its goals of non-discrimination. This is standard language that we see with the Alaska Human Rights Commission. We see it in all sorts of other jurisdictions. We see this a lot in non-discrimination laws. So this isn't anything out of the ordinary. Moving on page 2, number 11, we'll see this is the first of our checks and balances on the executive director. So the commission shall exercise general supervision of and direct the activities of the executive director. Again, balancing that power, and we'll see that throughout. And then this is really also clean up powers to designate hearing panels and reconsideration panels. That's something that the commissioners already do. This isn't changing anything. I think it's just clarifying that. So that's not something that I do as the executive director. And so moving deeply into this. So legal counsel, the municipal attorney is our legal counsel, unless, of course, the municipality is a respondent, and then I am the legal counsel. And then we'll see in section B, I am able to employ temporary legal counsel as needed. And that has been our procedure already. So this isn't really changing anything. This is clarifying and cleaning up. All right, so let's jump into the meat of our definitions. So the first definition is our accusation. We use accusation throughout Title V. It just hadn't been defined. So again, clean up, just making sure this is defined. The accusation is the document that moves us from the confidential investigation conciliation phase into now the public hearing phase. So it's very similar to like what you would see as a complaint in court. On the top of page 4, cleaning up the definition of commission, just making sure that that is very clear. When we refer to commission throughout Title V, we're referring to our commissioners, our volunteer commissioners. Again, complaint, we refer to it throughout. It had just never been defined, so more cleanup here. The complaint is when someone from the public comes to us and says, I believe I have been discriminated against.
Just want to note really quickly for the record that we've been joined by Mr. Constant. Thanks.
Thank you. More cleanup on employer. Employer means a person instead of saying employer means an employer. Person is defined already in Title V. You won't see it in this ordinance because we didn't make any changes to it. But person is defined in Title V as one or more individuals, landlords, owners, lessors, managers, real estate brokers, real estate salespeople, labor unions, partnerships, associations, corporations, legal representatives, mutual companies, joint stock companies, trusts, unincorporated organizations, trustees in bankruptcy, receivers, employees, employers, employment agencies, labor organizations, joint apprenticeship committees, other legal and commercial entities, or successors to any of those. So basically any legal or business entity that employs someone.
Just want to note for the record that we've been joined by Ms. LaFrance.
And so moving on to our familial status definition. So this is something that is new for us, but it's not expanding our jurisdiction. We already bring in these cases through a combination of age complaints with sex, which includes parenthood and pregnancy, but under our Title V definition, and marital status. So when we receive these complaints right now, they kind of get cobbled together through age, sex, marital status. Whereas if we have this familial status definition, we're covering the exact same jurisdiction, just it's a cleaner way to do it. We have one protected class instead of this variety of others. What we used here is the federal language. This the definition used by HUD. It's been tested in court. It's been used in a lot of other jurisdictions. We don't anticipate any issues with that. And then jumping into our gender identity definition. And before I go into kind of the how and why we made these edits, I again want to share that, this isn't expanding our jurisdiction in any way. This isn't going to be bringing in more cases or placing an extra burden on potential respondents. There are some real practical reasons why the current language doesn't work for us and just isn't necessary. So I think the first thing, kind of jumping to the bottom of the definition, not being asserted for an improper purpose, that type of language, that's a respondent defense. It's not something that belongs in a protected class definition. We don't see that in any other protected class definition, but it is a respondent defense that comes up in lots of protected classes. So, for example, and I only use this comparison to make this point, not because I otherwise want to compare these two protected classes, but when we get a complaint of disability, the first thing that we look at is, does complainant actually have a disability? Is this complainant actually covered by our law? And most often, a respondent will say, no, they're only asserting this to get these special protections. They don't have a disability. We contest that they have a disability. So it's a respondent defense. It's kind of awkward that it's inserted into this definition. It's something that comes into our investigations anyway for everything. Again, the first thing we look at is, does complainant actually fit into this protected class? Are they covered by this law? Do we have jurisdiction? And so all that kind of stuff already comes in there without having to be laid out in a definition. The other part is where it says, may be established by evidence of medical history, et cetera. It's also awkward to have language showing, how this may be established in a definition. It's not something that we see in any of our other definitions. So it just seems awkward and out of place. And then also, even though it uses may, it's still, we don't see this come up through medical history. That's not how, in our investigations, we establish gender identity. It's very rare, I think, that actually comes in. Sure, it may, but it's not common at all. So it's, again, awkward to have in our definition. So I think just overall, it's not really functional. I think having that type of language does more harm than good, and it's just not necessary. So the language we've proposed is language, again, federal language, has been tested. It's used in a variety of jurisdictions, and we think that it will work for us. It will be a lot more functional. I also wanted to point out that gender identity cases make up 1% to 2% of our caseload every year. So for example, we keep a caseload of about 100 cases. And so in 2016, we had one gender identity case. 2017, we had one. In 18, we had two, and those were actually the same complainant. In 19, we had one, and in 20, we had two. We've had one so far this year, and it has already settled. So this isn't something that we see very often anyway. Still important, of course, but it's not a big bulk of our cases.
Thanks. So before we move on, a couple of things. First, if members want to get in the queue, please use the system. And the basic way to get into the queue is just clicking on the three dots that are on the line, Worksession re-AO 2021-30. Click on those three dots, request to speak. Okay, so first we have Mr. Weddleton.
No, thanks. I'd say one thing, you gave me a lot of answers to a number of my questions, and you're free to share that with other assembly members if you want to, because it's a nice presentation you did. So in this one, the gender with which a person identifies and also includes, is that either or it's they identify as a woman, and I hate to be, and appears to be a woman and acts like it, wears a dress, I don't know, all those things. Do they both have to be together, or is it one independent?
So I think that gender with which a person identifies is an umbrella, and then under that umbrella, it can be, appearance, mannerisms, behavior, expression. It doesn't have to be all or any of those. But the gender with which a person identifies is the umbrella, is the definition that we're looking at. And then I think the rest is just helpful to kind of fill in under it. That's how I see it. Megan, did you want to add anything to that?
No, I think she expressed it well.
Can you speak into the mic, please? Thanks.
I don't have anything to add.
Okay, thanks.
Well, thank you.
Thanks. All right, and then just as another reminder, this isn't like a normal assembly meeting, so I can't take you all out of the queue. So once you get in the queue, please make sure you take yourself out of the queue after you're done. Ms. Allard.
Thank you. The presentation was great. So a couple of my questions is, as far as transgender, I'm not familiar with all the terms, so bear with me. How will it affect certain shelters of women of domestic violence that might be impacted by a transgender?
No, I can't.
And how do we address those issues? Is it in here? Could you kind of help me with that a little bit?
Sure. Thank you for your question, Assemblywoman Allard. I appreciate it.
Yeah, 'cause usually, like, to get to current items,
And
it
so,
has to be something.
like I started off, I think, this doesn't expand, this definition in particular, this piece doesn't expand our jurisdiction in any way. When we talk about shelters, there are a lot of pieces that come into it. We're going to, look at, is there public funding? We'll look at, is it a religious-based organization? We're going to look at, is it a communal type space, or are they, individual? What type of privacy is there? So it's really hard to give a blanket answer for that, because there are so many factors that come into it. When we talk about shelters, we also have to remember there's a right to privacy. And that's how a lot of shelters are able to say, we're a women's shelter, we're a men's shelter, et cetera. So all of these things come into play, and it's not something that this definition in and of itself is going to affect. It would, it's not going to change anything from the current law to this new one.
You said a lot of factors. Chair, may I? Thank you. You said a lot of factors come into play depending on the shelter. Mm-hmm. So I'm going to just say, how about the Hope Center? How will this impact the Hope Center?
And so as a former respondent, I'm not comfortable sharing exactly how we would deal with a specific respondent. I don't know enough personally about them or their current structure to be able to actually answer that. I'm happy to talk with you or someone from Hope more in depth, but I can't answer that right now for you. I'm sorry. I can say, though, that just changing this definition, it's not actually changing anything else jurisdiction-wise, or the type of case that we would bring in. That would come into more, we're going to talk about the public accommodation definition, and you might have more questions once we get there, and I think we might be able to dive a little bit deeper there. But I'm not comfortable speaking to a specific former respondent or potential respondent on how this would apply to one person or organization.
Thank you. Mr. Constant?
Yeah, thank you. Hello there. And, I will have to really sit down and think about all of these changes a lot. I think it's good stuff for the most part. And, the term and not being asserted for an improper purpose, it's an awkward term, but the fact is that's the big scary thing that a lot of people fear is that, someone who's not in fact transgender is putting on a dress to go assault people. Right, and it's very rare that something like that happens. There might be one case or two that have ever been recorded out of all of the many, many cases that are brought across the country in any given day. And so I don't need an answer right now, but I would love to have some more thought put into and maybe a conversation about how that's addressed in the code as opposed to just in making a statement, well, that should be an asserted defense or a statement made by a claimant of some kind. So I hope we can explore that a little bit, maybe offline.
Absolutely. Thank you, Mr. Constant. And And I appreciate those concerns, for sure. And we have partnerships, with a lot of small businesses in town, who might have those types of concerns. And we are available to them to work through this with them and make sure that we can craft something that works for our community. But I do think that is part of everything, really. It's part of all our work. It's part of all of the protected classes. And so that's something that comes into all of our definitions. And it's just part of our investigation. It's something that we're going to look at for any complainant, whatever their claim might be. We're going to look at, is this complainant sincere? Is this a legitimate allegation, or is this being done, because they're mad at their employer, because, whatever it might be.
And so what I think might be a workable middle ground would be to remove it from there and find a place to put a statement along the lines of, an assertion for an improper purpose is not allowed. Just a very simple phrase that could provide what you just said, the blanket that is considered in all of these cases. So it does strip it away, which I think then it would be very valuable and kind of helpful in this definition. Without something along those lines, I think that it leaves a hole. And so, but I think a separate location with just an asserted statement that an improper purpose is not allowed, or something.
Yeah, thank you. I'm happy to look to look into that more. I think that's a great idea, so I appreciate that. And then I also just want to share, sorry, 1 second. So when a complainant does come to us and file a complaint, the complaints are verified, meaning they are notarized. So, they are asserting that this is true, to their belief, and there is something to that. Ms. Carmichael was just pointing out that of the 23 states that specifically protect gender identity as a protected class, 5 of them use some type of language like this. So it is a minority of states that use this type of language, but it is still out there. And I think it's also important to note that, just this summer, in July, I believe, the Supreme Court ruled in Bostock v. Clayton County that gender identity is now included under sex discrimination, at least for employment purposes under Title VII. So I think that's another kind of factor that plays in here.
Thanks. I don't have anyone else in the queue, so please continue.
Yes, thank you for those thoughtful questions. Moving down, just clean up on those. You can see there, referring to the chapters. Then moving on to page 5, marital status. This is also a cleanup one. If you look at the deleted language and the new language, it's just makes more sense. It was kind of choppy and awkward before, but it is still, again, not expanding our jurisdiction in any way, still covering the same exact things. National origin. This was outdated language. This person's not citizens and persons naturalized. That's not language that's really used anymore by the EEOC or by other human rights or equal rights agencies. So this language that we used is taken directly from the EEOC. It's what's used in case law. So it's just more modern language. And it is, what we practice already anyway, because that's where we get our guidance from, right, from all of this case law. So again, not expanding our jurisdiction there in any way either. So moving down to public accommodation. This, again, is a standard definition that we see across multiple jurisdictions. It's pretty similar to ones that we find in federal law. It's pretty similar to the one that we see in AS 1880 and the Alaska Human Rights Law. We did add that accepts public funds. And so this, again, isn't unusual. So we see Section 504 of the Rehabilitation Act, which prohibits disability discrimination by organizations that receive federal funds. And then we also see this again, Title VI of the Civil Rights Act prohibits discrimination on race, color, national origin by any program or activity, again, that receives federal funds. So the idea of being subject to non-discrimination laws when you accept public funds is definitely not something new. We also see this in contracting all the time, when local or state governments contract with a private company to do some kind of work, it's usually in their contract that they have to abide by these laws. So not a new or, a different concept, but we did add it to this definition.
Thank you. I have a couple folks in the queue. Ms. LaFrance?
Thank you, Mr. Chair. Thank you for the presentation. I have a question about accepting public funds. How exactly is that defined and what constitutes it? Like, for example, if an organization accepted a one-time CARES Act grant, would that be considered accepting public funds for the purpose of the definition? Thanks.
That's a great question, Ms. LaFrance. Thank you. And I think that we can definitely think more about that. Ms. Carmichael, do you have any thoughts on that?
I'm in front of my microphone here.
To the right.
Can we see if we can fix that mic or switch it out?
Thank you. Okay, I think we're on. So when we looked at other definitions of public accommodations, other federal statutes often included this language about public funds. Often those statutes did not necessarily include a definition of what public funds are. I think it would just be a matter of sort of, canvassing where the individual funds came from, looking at case law. All of this is, you're applying the situation to the facts as they come. So I have not necessarily seen any hard and fast definition of public funds in the definitions that I've looked at, if that helps at all.
Thank you. Mr. Weddleton?
Yeah, so broadly, we're talking about places available to the public. What about like a private club? Is that?
So private clubs are usually excluded. There's a lot of case law on excluding private clubs and what is a private club and what isn't. And so generally, yeah, a private club will be excluded, but what is a private club and how is that defined? And that's going to depend on what jurisdiction you're in, what that case law is looking like in that jurisdiction.
So if you have like these VFW posts, where would that be? And then say something like a gym. You pay to be in the gym. You can't go unless you're a member. Is that a private club?
No, generally not.
And why not?
Because they do offer their services to the general public. Anyone can join if they choose to.
Okay.
And in the VFW example, generally when there's like a restaurant bar kind of feature usually, so even though if you're not a member, you can participate in events, then you are opening yourself up to being a public accommodation. Similar to like religious institutions, which will generally have some kind of exemption. But if they open themselves up as a public accommodation, so for example, if a company rents out a church, to do a function, that church, or for at least that function, is going to be a public accommodation during that time and space, even though it's a church itself. So, everything is really fact-specific when we talk about, what fits into these definitions.
Yeah. Okay. All right. Thank you.
Thank you. Ms. Zalatel?
Thank you. Actually, Mr. Weddleton, your answer to Mr. Weddleton's question got to mine, which was, what's the breadth of public accommodation? It seems that it's fact-driven and it's actually quite broad, and that's a separate question from the public funding question, correct? It's either or?
So I think it still has to be an organization that offers its services or offers something to the public. But if for some reason it's missing to get that hook into public accommodation, if it does accept public funds, then that's the hook. Does that make sense? I don't know.
Yeah, I don't think that reads this way, though. So I'll noodle on it and probably send an email. Thanks.
Thank you. Yeah, and that's definitely, I am happy to work with each of you or to have another work session and be able to kind of parse out some of this language and make sure that we get something that works well. Ms. Carmichael, did you want to add anything to the, okay.
Thank you. All right, I don't have anyone else in the queue.
Thank you. So moving on, staff, I read that long definition of persons earlier, so I just want to be really clear. We're talking about our paid employees. substantial evidence at the top of page 6. So this is the standard of proof that we see generally throughout administrative law. It's not just us. And someone had asked us a while ago to kind of expand a little bit more on what substantial evidence means. So we added more than a mere scintilla of evidence, which is just quoted from case law. That's what all the cases cite. And so it is a very low bar, but again, it is, the standard for administrative law.
Mr. Weddleton?
I don't know, I guess we'll run out of time if I nitpick too much, but, so I had to Google this, of course, until, that's not normal. It would be nice in all of this, normal people read this and put it, if there's a way to put that in more colloquial language when you hit these, because anyone can Google, of course, and then figure it out, but it would be nice if someone just can read it, make it easier. Thanks.
Yeah, thank you for that feedback, Mr. Weddleton. I agree with you, in general, for this type of work. I think my inclination is to, I guess it's my lawyer brain, right? Like I want to use the exact words that come out of the case law. But I think that's a great point and something that we can try to work on so that folks understand and know what to expect.
Yeah, I've come to understand that those little phrases do have a lot of meaning and are important, but maybe if we, in parentheses or a comma, which mean, or something, just to add that for
Sure.
other people.
Thank you.
Thank you. So 520.020 is our housing provision. So with the housing provision, you'll see that we have removed, and actually we'll get to that in just a little bit, but we have removed all reference to Section 5.25, the Fair Housing Act, and we'll talk about why just in a second when we get there. But what we did for 520.020 is just add familial status since we defined it in the beginning, and make sure that familial status is now a protected class covered specifically in the housing provision. Again, so we don't have to cobble together this age, sex, marital status protected classes. And so moving down the end of page 7, 520.060, talking about our educational institutions. And so, looking at the laws that apply to educational institutions, federal law has really kind of occupied the field in specifically disability discrimination in educational institutions. So we just wanted to make sure that what we're requiring, isn't in conflict with any of that large body of federal law. So that's why we added this language there in a manner inconsistent with federal disability protections under the ADA or IDEA. And then you'll see again in that next paragraph, unless otherwise required by law, because there are some federal laws that actually require educational institutions to do these things that we're saying not to do. So we just want to make sure that we're not in conflict and that everything is working is congruent together. And so moving down, religious exemptions. This again is a just cleanup. So this is the religious exception that says, you can give preferential treatment in employment, accommodations, et cetera, to persons of your same religion, but you are still subject to the provisions of this title in regards to all of the other protected classes. And so it's kind of awkward to say, you're exempt from religion, but you still have to follow, for all of these other protected classes, but then we inserted religion again there. So just kind of awkward language, and just for clarity, I think we wanted to remove that. I think maybe the purpose there was, it's only in certain circumstances, right? So it's persons of the same religion that is reasonably calculated to promote the religious principles. So there's this kind of caveat. And so I think maybe the intention was, since it's only under certain circumstances, then under all of these other circumstances, then maybe religion still applies. So I think that can probably go either way. We just thought it was a little bit awkward.
I do have a question from Mr. Constant.
Thank you. It's on the previous item, actually, familial status. I missed the first part of the definition because I wasn't here. Now that I see it inserted, the question I have, and I don't know if we have any of these in Anchorage, but does that apply to a kind of a neighborhood that was designed for like 50 and over, so it does.
Yeah, and that was one of the questions I had received earlier from Mr. Weddleton, too. And so federal law does allow, I think it's 55 and older.
Okay.
And so we wouldn't apply this in a manner that's inconsistent with federal law.
Okay, so the protection remains
The
for those
protection is there.
places because of federal law. Thank you.
Yeah.
Thank you.
Okay, so next is the removal of this Fair Housing Act. And in the AM, we went into that a little bit. So about 20 years ago, the Equal Rights Commission had sought a work-share agreement with HUD, similar to our work-share agreement with the EEOC, where we could also enforce the Fair Housing Act, Federal Fair Housing Act, parallel to our own housing provision in Title V. And so one of the requirements in order to receive that work-share agreement was that we had this specific language in our code. And so it's my understanding, looking through the historical documents, that this work-share agreement never materialized. So we never actually had it, but we had already inserted this in our code, and it seems that we just left it there. It's not something, as far back as I can see complaints, it's not something that we have cited to or used. We always use our 520-020 for housing cases. So it's not something we use, and it was the basis for an unfavorable finding for the municipality in the downtown soup kitchen case. So we decided, let's just remove it. It's not necessary. So moving on, top of page 9, correspondence. So this is already our policy, and again, we're just clarifying complaint confidentiality. We don't share with commissioners our complaints unless it has gone to reconsideration or it's in a public hearing. So commissioners are pretty insulated from our actual day-to-day work unless it gets to that level. So that's just clarifying that. And then down in complaints in section B, again, we're seeing the checks and balances on the executive director. So now, whereas currently the executive director can file a director's charge on behalf of a complainant, now the director needs approval by 3 commissioners in order to file that type of director's charge.
Quick question, oh, there's a queue, okay. No, quick question, Mr.
Go
Chair.
ahead, Mr. Constant.
Is there any basis for how the 3-member panel is chosen?
So I think we anticipated it would be like the reconsideration panel where it's up to the chair. The chair chooses, and in one part we talk about a rotating basis for the hearing panel, but I think that's generally all of our panels. The chair will choose on a rotating basis.
So it's not the executive that chooses?
No.
Thank you.
No, yeah, absolutely not. And that goes the same again for reconsideration panels, for hearing panels, for these types of panels. Definitely not the executive director who would choose them, it's the chair.
Do we think it needs to be spelled out?
I think that makes sense.
Okay, thank you.
Thank you. And just as an FYI, I can't take members out again, so.
I can't take myself out.
And I can't get in.
Okay, got it. Go ahead, Ms. Alatal.
Thank you. So I'm curious about what prompted this change. As I'm thinking through how a complaint moves through, or if a director wanted to bring a complaint, ultimately, would the panel of 3 commissioners that authorize the director filing the written complaint then not be a part of a hearing of that complaint? Okay, so
Right.
they would have to recuse themselves. So why are we now adding the panel of 3 commissioners? Because can 3 commissioners bring a complaint without a director? Like, does it work both ways?
So not in this section. When we get to the general investigation section, which we are going to get to shortly, so 550-060, it is the commission on its own motion or the executive director with approval of 3 commissioners can initiate a general investigation. And so the difference between a director's charge and a general investigation. So a director's charge would be, director stands in the shoes of a specific complainant. So someone calls us and says, this happened to me, but I don't want to file a complaint. Director can file a complaint in their name. So that's one way. And so now in order to do that, now we need approval, or the director would need approval from the commissioners. General investigation, those come about when we have one of our regular investigations, and in the course of that investigation, it comes to light that there is some kind of practice or policy that respondent is doing that is affecting a large amount of people. It's this widespread, the EEOC calls it systemic. So general investigation would be, we don't have a specific complainant that we're filing on behalf of, but we've become aware that this is happening and affecting people, and so we're going to now investigate this policy or procedure.
Got it. So still, why do we need 3 commissioners for a director's complaint? Like, what prompted this change?
And so I think there were director's charges filed in 2018 that brought about litigation. And so this is one of those checks on the executive director after that, as a result of that.
Thank you.
Can you hear me?
So, I'm sorry, was there someone on the phone?
Yeah, this is Diane Heaney-Mead, the chair of the Anchorage.
Yeah, can you hold on a second? We need to fix the audio on the phone. All right, can you go ahead, try again, please?
Hi, yeah, this is Diane. That was part of the reason that we added that, was because of the former director had filed a director's charge, and the commission wasn't aware of that and wasn't comfortable that we were not involved in that decision.
Thank you.
So it's quite a level of oversight.
Yeah, can you identify yourself for the record, please?
Diane Heaney-Mead, Chair, Equal Rights Commission.
Thank you. All right, so folks are going to have to flag me down if you want to get in the queue at the moment. So I'm not seeing anyone else. All right, go ahead, Mr. Whittleton.
Thanks. Maybe I'm backing us up here. On the Fair Housing Act, there were section, the 5.25030, parts 1 through 9 were exemptions. And that included, on one part is the exemption for shelters and so on. So, so what happens if if there were an amendment to bring these exemptions in to this code? What would that impact?
You know, I think it depends. I think we'd have to see what the exemptions look like. You know, how would it affect our investigations? How would we apply them? But I am open to looking at that and working with you on that. But I think it would just depend on you know, what we're looking at.
Well, I guess would you do that, please? I mean, of
Okay.
course, not right now, but let's say, you know, because I look at these, they were exempted before, and I'm not sure that all of them are now. It's not quite as tight. And just give us all some feedback maybe on where those brought in, what would be the impact overall
Yeah.
of your changes here. Thanks.
And I think part of the intention there was that, you know, in the downtown soup kitchen case, the judge found, and this was for a preliminary injunction, so it was not after a trial, so not necessarily on the merits, but the judge did find that because those exemptions were listed under the housing provisions, then in effect, those organizations are exempted from basically everything else, including public accommodation and anything else. And so in order to curb that, so I think there's probably a narrower or more narrow way that we can do that in a way that works a little better than how it was before. So that is something that that we'll look at.
Hi, this is Diane again. You know, when you look through those exemptions, it includes, you know, hospitals, homeless shelters, so, and it's part of the Fair Housing Act. So I think what those exemptions were intended to do was to exempt a hospital or homeless shelter from being considered housing. It wasn't to exempt them from all non-discrimination laws.
Thank you.
Thanks, Diane, and Mr. Weddleton, too. So I think we are done with page 9. And so moving on, page 10, we changed shall to should here, and this is really just for respondents. You know, a lot of times our respondents might be small businesses, they don't have an attorney, they may not answer this, you know, to this type of specificity or in a, you know, specific type of format. So we just want to make sure, it hasn't happened before, but we just want to make sure that, you know, there is this flexibility and that we're not going to have a complainant say, you know, this isn't valid because it didn't follow this. So we just changed that to should. Again, hasn't been an issue, but I think it just works a little better. Moving down, this is, again, just clean up accusation instead of determination. Again, the accusation is the document that actually triggers a public hearing. So more cleanup on page 11. And so 550.010, we added unless good cause is shown. So again, we haven't been challenged on this before, but I think theoretically we probably could be, the way it's written right now. Ideally, all of our investigations will be concluded within 240 days. We generally carry a caseload of about 20% that's over 240. The last year with pandemic, we're carrying about over 50% now of over 240, and we're really trying hard to work through that. And so we added unless good cause shown, just again, you know, to protect ourselves. We haven't been challenged on this at all. You know, we haven't had someone say your determination is invalid because it wasn't within 240 days. But just in case, I think this language is helpful. Again, it's always our intention and our desire to get these cases out as soon as possible. But especially when, you know, we might have a large respondent and we may be, you know, jumping through hoops to get evidence or trying to get witnesses to come in to interview. So, you know, it does extend, unfortunately.
Thank you. I do have a question from Ms. Zalatel.
Thank you. So the 240 days and good cause, so I'm trying to remember, the 240 days starts after attempts at conciliation. No, it starts from the date of the initial alleged action. I can't quite remember the calculation.
Yeah, so conciliation happens after an investigation when we have found substantial evidence of
Okay, I mean the first attempt to bring the parties together.
The fact-finding conference.
There we go.
Yeah, so fact-finding conferences are generally scheduled 2 to 3 weeks after we receive a complaint, after a complaint is perfected. So the 240 days starts from when we receive that complaint.
Okay, and then what kind of documentation do you intend to have for good cause? Like how do you intend to make that determination and ensure that you've got it documented?
Yeah, and so we use a software system called Time Matters, and we document every single interaction with respondent and complainant. And generally, I think what good cause is when we look in Time Matters and we look at those case notes and we see, you know, reached out to respondent for interview this date, reached out this date, still not hearing back on this date, sent a pre-subpoena letter this date, you know, and it just keeps going. I think that is what we look at for good cause.
Would you be open to the idea that if good cause is found to extend, that notice be given to the parties? Because I think, you know, having represented complainants at least, they feel like 240 days is already a long time, and it's kind of the time that they're counting on in some ways, like literally counting. And so if it's extended and it's extended for, you know, whatever it seems to be the reasonable amount of time, whether it's a 30-day extension or a 60-day extension, at least it's a follow-up time so they can make appropriate plans and, you know, kind of have an expectation. So it's a thought, and it's something I think worth discussing, because I think the more certainty that can be provided to particularly a complainant about how long, and also then on the respondent side, if you're trying to get evidence, you're like, well, we've extended for 30 days, like, we've got to get this done, it keeps the ball moving.
Yeah, and I know that our investigators really try hard to keep complainants in the loop and make sure that they know what's going on. But that is something that we can think about for sure. Thank you. And so C here, first we remove the witnesses, so we don't allow witnesses at our fact-finding conferences. We haven't for as far back as I could see. Our longest-term investigator has been there 7 years, and she says, that's how she was trained. So since her time, at least, we've never allowed witnesses. So I see these fact-finding conferences kind of like mediations, where the fewer people in the room, generally the better. We want respondents to be as open and honest as they can here. We're also having settlement discussions here, and we know that too many people in the room is going to be chilling to a respondent who is working on settlement discussion or settlement negotiations. So that's the purpose here. And then we added this language, and I think on its face, it can be a little off-putting, and I want to talk about it. Complainant may be accompanied by one support person or an attorney. Respondent may choose no more than 2 representatives to attend in addition to an attorney. So why does respondent get 3 people and complainant gets 1? So what we see with respondents, the bulk of our cases are employment. So with respondent, we need someone in the room who is a high enough management level that he or she has authority to settle. And then we also want someone in the room who has direct knowledge of the allegation. Those 2 individuals are rarely the same person. So right off the bat, we have 2 representatives from respondent. And then, of course, everybody can have an attorney. So that's why respondent is allowed more people. For complainant, generally it's one support person or an attorney. I think after thinking about this and reviewing it a lot, I think it's fair to say something like, unless good cause shown. Of course, if there is a reasonable accommodation request for a disability, so if an individual needs someone else there with them in addition to their attorney, that will of course be granted. But I think there could be cases where an individual may be very intimidated by a respondent, or English may not be their first language, and they may not need an interpreter, but they would still feel more comfortable having someone with them. And so thinking about this more, I think it would be more fair to say one support person and an attorney, or one support person or an attorney unless good cause shown, or some other kind of discretionary language. This original language came about generally, so in my experience as a mediator for Asher, this was our rule. It was a support person or an attorney, and that worked well for us in mediation, again, because of the settlement negotiations and so forth. But I think there are special circumstances where this language might be a little limiting.
Thank you. Ms. Zolotel?
Thank you. Yes, my recommendation or suggestion would be that just to indicate that both parties can have an attorney present, and then specify if they can have 2 representatives or a support person, as you've detailed. Because when you put an or where you have to choose between a support or legal representation, it doesn't seem right, especially if an individual is going through this and has a partner or a spouse. You could see they're wanting to be that need, or, as you've indicated, a reasonable accommodation was required. And placing that onus on a probably already very nervous and stressed out complainant doesn't seem like the route to go. Thanks.
Thank you, Ms. Zolotel. Moving down to E, no person may make an audio or video recording. Again, these fact-finding conferences are similar to mediations. We're negotiating settlement. So that's pretty standard that you're not recording settlement negotiations. We don't record them either. Moving down, it is just cleanup on these section numbers. And page 13, B. Okay, so here, our policy right now is that if a respondent is refusing to respond, it may be treated as an admission of the allegations in the complaint for purposes of an SE determination. So instead of that, we have the commission staff will analyze the available evidence to them, and based off of that, determine whether or not there is substantial evidence. Of course, we also have our subpoena power that helps in these situations. I know Asher and other human rights agencies have this type of language. They have it's treated as an admission if you're not responding. Again, because as an administrative agency, we do need some teeth, and that was a little bit of our teeth. But I think it is fair for respondents to rely on our subpoena power instead. And so here's the general investigation.
Mr. Chair.
Mr. Constant?
Thank you. In the spirit of what Mr. Wellerton previously stated, I think your Latin term there is a rare example of Latin in our code. And yeah, right there. I'm not sure if that's essential to the additional language or if we need to define that more clearly.
Okay, thank you. Thank you, Mr. Constant. So general investigations, like we talked about, these are the ones where we're not standing in the shoes of a particular complainant, but through another investigation or through other means, it has come to our attention that there is some kind of policy or practice going on that we want to look at. And so for this one, the commissioners can do it on their own motion. And that was already in the current title. We just added that for clarification, and then added the panel of 3 commissioners for the executive director.
Mr. Weddleton?
Oh, thanks. I don't know if I'm where you are on this, but B, are you on that bottom B? Am I ahead of you? The information, I'm sorry, where you can ask for race, color, sex, religion, natural order, blah, 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 of any employee, and I know you responded in my email as well, and you said that the state requires collection of those, then I'm in trouble, because in my business, we don't ask that kind of stuff. I mean, I know if they're male or female because of insurance and stuff like that, but I don't ask the other stuff. I mean, am I supposed to be asking this nosy stuff?
And so it depends. It depends whether a particular business is covered by specifically AS 1880 or by other federal laws that require this type of information. And so maybe, I guess, is my legal answer.
No, that's fine. I'll amend maybe in there somewhere. If this, and I had a complaint against me last year, and it got thrown out as, not to the city, but the state, as there's no basis for it. So a little bit of experience, so I kind of know the angst, what's going to happen here, and they didn't ask these questions, but I would have trouble getting these. I'd have to go back to all my staff and ask them these things. And so like I said, I don't know, some way I'll look, and if you can provide something to make it more clear who is covered and who not. Because this affects, real people and small businesses and so on.
Thank you. All right, so we're going to go ahead and keep going until we get to 550, 80 subpoena, and then we're going to have to pause because we're out of time.
Thank you, Mr. Chair, and thank you, Mr. Weddleton. I did note that, so let's make this a little more clear. Moving on, subpoena 550-080, and I think we'll close here. Again, this is just cleanup. The only change we made was after issuance of an accusation, not determination of conciliation failure, because what actually triggers the public hearing is the accusation, not the conciliation failure. So that doesn't actually change how we operate.
Okay, great. So thanks so much for walking us through, that was about half of it. So we are gonna go ahead and schedule a second work session for the 21st to finish the second half. And then if there's any follow-up that members have on anything, we can also try to squeeze that in at that time. So with that, I will go ahead and close this work session. Thank you so much. We're gonna get started with the special meeting at 2 o'clock.